may proceed.
Name for the record, please.
Karen, K-A-R-E-N, middle name Gullberg, G-U-L-L-B-E-R-G, last name Cook, C-O-O-K.
Ms. Cook, you are an attorney in the state of Michigan, correct?
Correct.
And in fact, your practice predominantly relates to juvenile work?
Yes, and some probate work also, and licensing.
And in fact, since 1987, you have been taking juvenile court appointments?
Correct.
You're familiar with Judge Gorcyca in Oakland County Circuit Court?
Yes.
You get appointments to her court?
Yes, through the rotation.
Okay, and the rotation means a individual who is at the clerk's office in Oakland County and appoints, correct?
Correct. Her name's Nicole Rude, and there's a juvenile rotation list.
Is there also an emergency list?
You can sign up during the day for the emergency list.
Are you on that list?
Well, it depends on what day it is. I often do not sign up because I'm not available. I only sign up if I think I'm going to be available.
Did you sign up for that list on June 24, 2015?
No.
Did you get a call on June 24, 2015?
Yes.
Who did you get a call from?
Nicole Rude.
Are you on the regular juvenile assignment list?
Yes.
And when you received that call, where were you?
I was sitting in my car eating lunch.
Do you recall, or if you know, what time that was?
I didn't know the exact time, but it was around noon.
Did Ms. Rude, that is her last name, correct?
Yes, R-U-D-E.
And did she provide you with any information as to the type of case that she would be assigned to?
Yes.
What was the type of case?
She said that a 9-year-old was facing possible contempt charges.
And obviously, whose courtroom?
And she told me to go to Judge Gorcyca's courtroom if I was available.
Do you immediately go to that court?
Yes, I basically ran through security as fast as I could and got on the elevator and got up there as fast as I could.
And when you get up to Judge Gorcyca's court, who do you see? Who do you come in contact with first?
I have very little memory, but it was some clerk. I asked where I should go.
It wasn't Judge Gorcyca, was
No.
it? Okay. Did you saw any pleadings from the case that was underlying this contempt or impending contempt?
No.
Did you see any transcripts or orders, anything?
No.
Did you talk to the dad's attorney?
I don't recall doing that, no.
How about the mother's attorney?
No.
And you already stated you did not talk to Judge Gorcyca, correct?
No, correct.
Did you meet with a child? I will refer to her as NT.
Yes,
And where was it that you met with her?
in a jury room.
And how long are you with this child?
It was somewhere between 15 and 20 minutes, the best I can recall. Had I known I was going to be testifying today, I would have taken copious notes, but that was almost a year ago.
Okay. And you were present in court when this child was found in contempt, correct?
Correct.
You saw when she was handcuffed?
Yes.
Did you follow her to Children's Village?
No. I had if I remember, it was either 1 or a 1:30 hearing that day.
And where was that hearing? Whose court?
I don't recall.
Was it in St. Courthouse?
Yes.
Since June 24, 2015, did you file any motions on behalf of this child?
No, I was released after the next review, and that was, I believe, July 10th on a Friday.
Between June 24th and July 10th, did you file any motions on behalf of the child?
No.
On June 24th, did you go to Children's Village at the end of the day to
No.
meet with this child?
No.
Did you see the child on the next day, 6/25?
I saw her sometime between the day she was held in contempt and when I left for vacation, which was around July 9th, and I looked in my appointment book last night to see what day I saw her, and I didn't write it down. So I saw her sometime between that and the next review hearing.
Let me show you what has been marked as examiner's proposed exhibit 144.
Your Honor, I'm going to object. This exhibit is part of the Children's Village records. The Children's Village records in this matter are completely irrelevant. Matter of fact, I'm asking Ms. Cook about this after the June 24 hearing is irrelevant to the four corners of the complaint.
First of all, you did not bar anything about after June 24th. Number two, if I may tell the court, this is a sign-in record. At this point in time, I haven't moved for the admissibility. I may, but at this point, I'm using it to refresh her memory, and certainly I can use anything to refresh memory.
I may use 144. I have 144 in front of me. You may, and I think you're referring specifically to the third entry, to refresh your recollection.
Correct.
That she was visited. Overruled for purposes of refreshing recollection.
For the record, Ms. Cook, did I hand you a sign-in sheet or a record of visitor log?
Yes.
Okay. Do you see your name on there?
Yes, July 1st at 12:34, I signed in, apparently. See Natalie, or see the child, NT.
That was on July 1st, not July 9th, correct?
No, I left for vacation on July 9th.
She said before July 9th, sometime before.
Yeah.
And you mentioned that you went on vacation on July 9th, correct?
If that was a Thursday, yes.
And on July 9th, were you aware of the fact that there was a hearing going to be scheduled with respect to your client as well as her siblings the following day on the 10th?
Yes, I got a call from the judge's office saying the hearing was moved up, and I had a vacation planned for a year, so I asked the court if I could find a substitute, and the court allowed that.
Between June 24th and July 9th, other than the call regarding the hearing on the 10th, did you receive any other calls from the court?
Not that I can recall.
Did you get any calls from Judge Gorcyca?
No.
Who covered for you on July 10th?
Michael Dean, with the court's permission, who was the attorney for one of the other children.
Did you ever take a tour of Children's Village?
In my whole career,
Yes.
I've seen parts of J Building, which is for boys, when they put an addition on approximately 10 years ago before they housed people. And I've seen the bedroom of the girls in Mandy's place, the shelter facility, because Judge James Alexander had ordered me to help get some girls settled in there. That's the only two places I've seen other than the areas where the attorneys are allowed to meet with their clients.
Attorneys can visit their clients anytime, correct?
Yes. Oh, and one other thing, I've been to some of the outbuildings to meet with clients, but none of the back bedrooms.
Nothing further.
Cross.
Morning, Ms. Cook. How are you today?
A little nervous, thank you.
Don't be nervous.
Okay.
At least don't be more nervous than me.
Okay.
Let's talk a little bit about Karen Cook. How long have you been an attorney?
40 years.
And how long have you been practicing in juvenile law?
29 years.
And how was it that you got into practicing in juvenile law?
I moved back here from Maryland after getting divorced, and I needed a job, and I was looking for one, and my parents built a house, and the builder's daughter was working for Judge Norman Barnard in probate court, and told me I should look into getting some court appointments, and I started in probate, a few years before I started juvenile.
And over time, it's become the large portion of your life?
Correct.
Okay. Well, what percentage of your practice do you think concerns working with juveniles?
Probably about 85%.
In the course of your career with juveniles, had you ever seen, prior to June 24, any child held in contempt?
Well, I have seen status offenders have their position as being in non-secure placements revoked because they violated a court order. So if you consider that, yes.
And how many of those hearings do you think you had?
Oh, probably several hundred.
Okay. Are you a member of any particular specialized bar associations concerning juveniles, or a member of any government task forces?
I'm a Children's Law Section Counsel. I've been serving a number of years. I've actually lost track of what term I've had. I think I'm on my 4th or 5th term. The Children's Law Section Counsel. I've been a member of the ABA. I'm not currently now. The state of Michigan sent me, paid my tuition to the ABA conference in 2010, dealing with children on the condition that I train other attorneys. I'm a member of the Oakland Bar Juvenile Committee. I'm the publication chair for the Michigan Child Welfare Law Journal.
And so you're particularly concerned with juvenile welfare and juvenile status, correct?
Correct. It's my passion.
Okay. Now, when you were called by Nicole Rude, you indicated that you knew that a 9-year-old was going to be in a contempt hearing, correct?
Correct.
You understood at that time that it was a civil contempt hearing?
Yes.
Okay. What is the difference between a civil contempt hearing and a criminal contempt hearing?
Well, the civil contempt, you hold the jailhouse keys in your hand. So, for example, when a reporter is asked to give up a source and the reporter says, I'm not going to do that, you go to jail, and when you want to reveal the source, the reporter would say, I'm ready to be released from jail. Criminal contempt would be, as I would imagine, a specific term of incarceration for violating a court order.
Okay, so a criminal contempt is for the punishment of a past order, would you say, versus a criminal contempt, which is encouraging compliance with an order moving forward?
Right. I'm not an expert on contempt, but yes, generally.
Okay. Did you understand when you arrived at the court, you said you did not speak to the judge, correct?
Correct.
And did you speak with Bill Lancet?
Yes, and I think it was on the way into the jury room. It might have been after, but I believe it was on the way in.
And so before you met with your client, Natalie, you met with Bill Lancet briefly, or spoke with Bill Lancet?
I spoke to him briefly, yes.
And he brought you up to speed on what was happening?
Yes.
When you went in to meet with your client, Natalie, did you have a pretty good understanding of what was happening at the court that day?
Yes, because I understood from Mr. Lancet that the kids had been acting up during...
Objection, hearsay?
Any response?
Your Honor, okay. You understood that Natalie had been was about to face a contempt hearing because of a failure to participate in parenting time.
Correct.
Objection, hearsay?
The only way she would have gotten that would have been hearsay.
Fair enough, Your Honor. When you met with your client, you had an understanding of what was going on, and you were able to give your client appropriate advice?
Correct.
Okay, and you said you met with your client about 15 or 20 minutes, I believe?
Correct. I don't have the exact time.
Do you think 15 or 20 minutes was an appropriate amount of time to meet with the client?
It was because the child was extremely defiant and would not cooperate with me.
What do you mean by that?
Well, I can't tell you what she said because of attorney-client privilege, but she was very defiant and didn't act as if she wanted to assist me in her defense.
Were you able to provide her with the advice that you thought she needed?
Yes.
And did she appear to be understanding your language and what your words?
Yes, she's very smart, was my impression.
And you had enough time, you believe, to at least explain a civil contempt issue?
Yes, and had I needed more time, I would have asked for it.
And did you believe you needed more time?
No.
Okay. Now, when you went on the record that day, you said to the court that, well, let me ask you this. When you went on the record, did your client actually refuse to participate in the parenting time orders?
As far as I know, she had, that the kids had been...
Objection, that calls for hearsay?
Your Honor, the video has already been shown. I think the statements that were made on the record are already in evidence.
If you're asking what she said, that's one thing. What she understood is another.
Well,
that would be the only source of that hearsay, so it's sustained.
the only source of what Natalie understood?
What this witness understood.
You recall this hearing?
Yes,
Okay. Did your client refuse on the record to participate with parenting time orders?
yes, and she, but then later she apologized to the court.
She apologized to the court.
Right,
And she indicated that she would participate in parenting time with her father, correct?
right,
Did she then change her mind?
yes.
And how did that come about?
Because her brother, her,
Objection, hearsay, that calls for speculation. Why?
Overruled.
Go ahead.
her, not her oldest brother, the 10-year-old brother.
Rowie.
Objection, Your Honor, now that calls for a total speculation as to what is in a child's mind and why, whether it's the older brother or the younger brother.
Overruled.
It's the middle child,
The
Rowie.
middle child, when the judge suggested that, or told them that they need to go to lunch with their father, at that point, he said something to the effect of, "I'm not going to do that." He refused. I can't remember his exact words, and then she refused.
So after she had agreed to participate in parenting time, she refused again.
Yes,
Do you agree with me that that was within the view and presence of the court?
yes,
Under those circumstances, do you believe, in your experience, that the judge had the discretion to hold your client in contempt?
yes,
Objection, Your Honor.
Basis.
Judge, she's not testifying as an expert. He already barred expert testimony. Now he's asking her for expert
Call for a
testimony.
legal conclusion, sustained. Proceed.
Did you object to the court's finding that Natalie was in contempt?
no,
You did not object on the record.
no,
Why did you not object on the record?
because I didn't think it would do any good at that point, and I was, she directly defied a court order, and I didn't believe that that was in her best interest. My plan was to go over to the village subsequently, build up a rapport with her and have her, because she then would have some confidence, I was hoping with me, to say, yes, I will now have a relationship with my father. At that point, it wasn't going to do any good, in my opinion.
Did you think that there was a basis to object as you saw the hearing proceed?
No,
Did you file an appeal of the judge's ruling?
no, it was set for a review in September originally, and I wanted to get some more information. My plan was to go and read at least some of the files. They're voluminous, to get more of a background, read the GAL reports in the file, etc. So I do a lot of appeals, but at that point, at that minute, when I did not object, I had a plan to try to build up a rapport with her, and we were going to have a few months of review. And I asked the judge if I were getting a release, and at first she was going to release us, and then she changed her mind.
So you didn't seek any appellate remedies at all following this hearing, correct?
No, but I have 21 days, so, and the review was moved up prior to any 21-day time period. I'm not sure I would have or not. I needed more background before I
Fair enough.
thought of filing an appeal.
Were you concerned at the judge's demeanor during that hearing?
No, I think that part of the problem with juveniles today and children is that there's not enough respect, and adults don't have.
Objection, really doesn't matter what she thinks.
Sustained.
Do you believe, did you have a problem with how the judge had described Children's Village?
No,
You are familiar with Children's Village, correct?
Yes.
You've been both in the back areas of J Building, you said, as well as in one of the bedrooms of the girls, right?
right.
Let's talk about J Building for a second. Does J Building have cells?
The part that I was allowed to visit, which was an addition about 10 years ago, yes.
So how are these cells arranged?
It's been a long time, but it's one child to a cell, and there's a toilet and a bed.
An open toilet, not blocked off?
Yeah, not blocked off.
And these beds, I believe, are, and correct me if I'm wrong, are concrete blocks with a mattress on top of them, correct?
That's what I've heard. I don't really recall because it's been a long time.
Okay, well, does the cell door, is it a solid door or is it bars?
I don't recall.
Do you remember whether it had a window in it or not?
There's a window. There's glass somewhere that you can see in.
Okay, so you can look into the rooms, correct?
That's in the new wing. I've never been in the older part of J building.
Okay, so if the court had said that the children could be spending time at Children's Village in cells, there's a part of Children's Village that has cells.
Correct.
And there's a part of Children's Village with open toilets that can be seen through the windows of these doors or bars, correct?
Correct.
And there's an uncomfortable bed there, correct?
Yes.
And the judge did not describe Mandy's place that way, but in fact, on the record, described Children's Village that way, correct?
Correct.
What do you think the judge's intent was? Well, never mind.
Yeah, that's a quick...
I got it, sustained. I get it. But there are... So when the judge was describing Children's Village that way, she used some stark words, correct?
Correct.
And that did not concern you at the time?
No.
Did she appear to be berating your client?
She appeared to be frustrated.
Are you from? How many times have you been in front of Judge Gorcyca again?
Let me see. I had a delinquency case that I was representing a former court employee's client, so that was one. A pretrial that got transferred to Judge Langton too, and a trial several years ago, so not many times. I can count, I think this might have been the fourth time. It's possible there were others. Those are the only ones I recall.
What is your experience with Judge Gorcyca's demeanor on the record overall?
Objection, relevancy?
Let's keep it to the 24th or the 10th, but she wasn't there. Let's keep it to 24th.
You felt that Judge Gorcyca was frustrated.
Yes.
Would you say exasperated?
Yes.
Did the judge appear to be angry?
A little bit.
Was she yelling?
I don't recall her yelling.
When you left the hearing, however, did you feel that that hearing was over the top or completely unusual?
Well, usually I've been a parenting coordinator in a GAL in divorce cases, and it was a little unusual to be holding children in contempt in divorce cases, but I have seen children held in contempt previously on status offender cases, so.
Let me focus that a little better. Did you believe when you left that hearing that the Judge Gorcyca's behavior was over the top or completely unusual?
Objections to relevancy, that's for you to determine.
Your Honor, I think that this witness who was present at the hearing...
She can testify as to her opinion. Go ahead.
No.
But there was nothing in that hearing that made you think to yourself, I ought to report her to the Judicial Tenure Commission, was there?
No.
And you did not report her to the Judicial Tenure Commission,
No.
did you? Now, in your experience in the Oakland County Circuit Court and in other courts, have you ever seen a judge instruct a deputy who is taking somebody into custody not to use handcuffs?
No.
Objections to relevancy, what she has seen in other cases.
Sustained.
In this case, were you surprised that Natalie was handcuffed?
Not at all.
Why is that?
Because that's standard operating procedure for the Oakland County Sheriff to transport children. And I've seen children in leg irons even.
So every time that you've seen children taken into custody, you've seen them handcuffed and/or leg ironed.
Well, usually the leg irons when they're coming from the village, but yeah.
Do you think that the judge had anything at all to do with the fact that Natalie was handcuffed in this manner?
Objection as to relevancy basis for her opinion.
Sustained.
That's something you expected to happen if the child was taken into custody.
Objections to relevancy, what she expects.
Overruled.
Yes.
And it did not surprise you at all.
No.
During the investigation of this phase of this case, you met with Margaret Rainier, is that correct?
Correct.
Did Ms. Rainier ask you any questions that you felt were concerning?
Yes.
What kinds of questions did she ask?
Objection, that has already been ruled on. I don't know what counsel's going into, but that is done and over with in those allegations.
We've ruled on that on Friday.
Your Honor, I agree with that. The only reason I asked the witness is because I think that I have to make an offer of proof at this point because I did not identify those witnesses in my motion who would be testifying to these issues. And so my offer of proof would be if this witness was allowed to testify on this issue, that she would be one of the witnesses that was asked about the ethnicity and or nationality of the children. She was one of the witnesses who was asked about the ethnicity and nationality of the judge. And actually, as I recall, and Ms. Cook can correct me if I'm wrong, I believe that Ms. Rainier was also very focused on Ms. Cook's nationality as well. So that's my offer of proof.
Sustained.
Give me-
For those reasons I indicated on Friday.
I understand. If you'll give me just a second. No further questions, Your Honor.
Direct. And again, I believe that direct cross your direct done with each witness, other than Judge Gorcyca, unless a new matter is raised on redirect. You may proceed.
Ms. Cook, you testified that this 9-year-old child didn't want to assist you in her defense, correct?
Correct.
And so with that, did you approach either the court, Judge Gorcyca, or contact the clerk back upstairs, Ms. Rude, to say, look, I can't represent this person because they cannot assist me in their defense? Did you do that? Yes or no, ma'am? Did you call Ms. Rude to say this young child cannot assist me in her defense?
That would have been inappropriate.
Okay. Did you do that?
No, but I think the question does not call for a yes or no answer.
Okay. Did you ever meet with this child before?
No, I met her that day.
Now, you said that you wanted to get the background of this case after the contempt hearing, correct?
I had some background, but when I'm representing a child and I haven't been on a case previously, I generally go read every file on either Court Explorer or in the archives or whatever to find out all the background.
Okay. And that's what you wanted to do in this case, did you not?
Correct.
Isn't it true that shortly after this contempt hearing, you went someplace on vacation, a family outing, did you not?
It was not a family outing, as I told you.
Object to relevance, Your Honor.
Of course it's relevant, Your Honor. If this individual testifies that this is what she wanted to do, she wanted to brush up on this file, when was she supposed to do that? And what action she had taken? It's very relevant.
This is Judge Gorcyca's hearing, all right? So let's keep it to that, all right?
The first time you saw this child was on July, I believe, 1st, you said?
No, that's
I'm
not the
sorry.
first. That's the time I went to Children's Village. The first time I saw her was the day I was appointed.
Okay, and since the contempt hearing, the first time you saw her thereafter was on July 1st, correct?
Yes.
Did you see her on July 2nd,
No, I
3rd,
have. No, I have other cases. I wasn't planning to go to Children's Village every day. The review hearing was set in September.
Okay, so you were fine until September, right?
Not fine until September. I wish you wouldn't be twisting my words. No.
Now, let's talk about Mandy's Place and the J Building. J Building is designated for boys and girls, or girls?
J building J stands for basically juvenile jail.
Okay, so juvenile delinquents, correct?
Correct.
And so you said that there were cells in there?
Yes.
You're talking about cells with bars on them?
I can't recall. I've only gotten a tour before they housed the boys there in the new wing, which was approximately 10 years ago. It's a locked, secure placement, as defined in MCR 3.903B3.
J Building is not Mandy's Place, is it?
No.
What is the name or the designation for that building?
It's a shelter care facility, which is different than a secure detention.
Does it have a letter to it?
Does it have what?
A letter, like this, the first one was J Building.
It used to be called H Building, and they changed the name.
To your knowledge, Mandy's Place doesn't have cells, does it?
Not to my knowledge.
And it doesn't have bars, does it?
I've never seen any.
There is privacy in the bathrooms, isn't there?
I've never been in a bathroom in Mandy's Place.
Ever seen kids in divorce cases sent to Mandy's Place on contempt?
Objection relevant, Your Honor. If we're going to keep it to the hearing, what's good for the goose is good.
That is what counsel asked.
Go ahead. Can you reply to what,
I don't recall. I don't think so.
Nothing further.
and thank you. Ms. Cook, you may step down.
Thank you.
May I just have a couple, Your Honor?
Was there any new matter raised on redirect?
Yeah, I believe there was. There was the question about whether she felt Natalie could assist in her defense, and there was also the question about Mandy's Place being a non-secure detention facility.
You may proceed about the question about assisting defense. That's the only matter that the additional inquiry. Go ahead.
You felt that Natalie was a fairly intelligent child, I thought you said,
definitely.
correct? She understood, at least you believe she understood what you were telling her.
Correct.
And she was able to respond appropriately.
Correct.
She was not somebody who, by reason of insanity, could not assist in their own defense.
As far as I could tell.
The fact that she might disagree with the advice that you give does not mean she's not assisting in her
Correct.
defense.
I wanted her to tell me specifically what she felt she had done wrong, and when I said on the record that I didn't have a complete narrative, that's what I was referring to. But I did get her to apologize on the record, which I thought was a victory. So apparently I made enough of an impression on her to get her to change her mind.
But it was Natalie who didn't give you the complete narrative.
Correct.
Not because she couldn't.
It goes along with the kids not wanting to cooperate. The whole milieu of the case was the lack of cooperation with the children and the visitation.
Okay, fair enough. Thank you.
Anything further?
No.
Counsel? Cook, you may step down. You may have to discuss your testimony. Next witness for the examiner. Raise your right hand. True self,
I do.
All right. Please state your name for the record.
Michael Patrick Anthony Dean, P number 32631.
All right, thank you, Mr. Dean. All right, counsel, you may proceed.
Mr. Dean, you are an attorney, are you not?
Yes, I am.
And you're licensed in the state of Michigan?
Yes, I am.
June 24th of 2015, did you have an occasion to go to Judge Gorcyca's courtroom?
Yes, I did.
And how is it that you happened to be called up there?
I was called by Miss Nicole Rude, who is case service person, stating that there was a need for an attorney in Judge Gorcyca's courtroom.
Did you know who your client would be? Was it a juvenile or an adult?
I was informed that it was going to be a young adult.
And when you appear in Judge Gorcyca's courtroom, do you meet with anyone or see anyone?
Well, the courtroom was, there were people in the courtroom. I believe I approached Judge Gorcyca. I don't remember specifically, but my routine would be I would approach Judge Gorcyca's clerk and ask where the person is that I'm assigned.
Did you see your client at some point in time?
Yes, I did.
Before seeing your client, did you have a chance to review any orders? Any pleadings?
I'm sorry?
Any pleadings, any orders?
Not that I I think I talked with someone.
Who was that?
Might have been Mr. Bill Lancet, just to find out what was going on in terms of that's who I think I might have talked to.
Okay. And where was your client when you first saw him?
He was in a room on the other side of the hallway, on the where like the jury room is and the judge's chambers. He wasn't in the courtroom, correct?
But he was not in the jury room, or he was in the jury room?
I have no idea what room he was in, be honest with you.
Whatever room he was in, was he alone? Was anyone with him?
I believe he was alone with a lay person in that room.
I'm sorry, with what?
Like a lay person. It could have been a therapist, some other person. I don't know who was in the room.
Did you ever identify that individual?
No.
When you met with your client, did that individual stay in the room?
I believe that client left, or I asked that client to leave.
I'm sorry, client or person?
Well, I left I believe I asked that person to leave. I believe it was just Roy and I in that room.
Mr. Dean, we're using the children's initials.
Oh.
So it'd be RT for purposes of the proceeding.
Will do, sir.
That's perfectly fine.
What did you advise your client? What did you tell your client?
Well, basically, at that time, I determined or became known that basically the judge wanted to have some interaction between my client and his father, and the Judge Gorcyca was promoting that my client, I believe also along with the siblings, go downstairs to the cafeteria and break bread with their father, have lunch, and just basically listen to their father talk,
And in fact, did you not tell your client that he didn't even have to speak?
I told I told my client that, in fact, I believe that the Judge Gorcyca was trying to start the road to recovery and trying to build a relationship between my client and his father. And I believe I said this is going to be a long process. I believe I told my client that you don't even have to talk. You just sit there, listen to your father, you listen to us to stay, and basically that there would be, down in the cafeteria, there'd be a lot of people around. I believe I was informed there were going to be even some support personnel if need be, and if he didn't, and that's all the judge was wanting to start on this road to recovery.
At some point in time, was a hearing held?
After I had met with my client, yes, we went back into the courtroom.
And what happened in the courtroom?
Well, prior to going back into the courtroom, I believe that, my client understood what was going on. I believe that my client was going to cooperate and listen, and basically go downstairs and have some time with his father, and basically we went before the judge and it flipped.
Okay. When you first got the call from Ms. Rood,
Yes.
what time was it roughly?
I want to say probably about sometime between 11 and 11:30,
And what time was it when you first saw your client?
Well, I was in the courthouse, so it was shortly afterwards. I would have to say, I make good tracks in the courthouse. I got up there a
And
decent
how
amount of time.
how long did you spend with your client before going to the courtroom?
I'd have to say probably an honest 15 to 25 minutes or so. I did, introducing myself, just...
You saw your client found in contempt?
I'm sorry?
Did you see your client found in contempt?
Yes, I was standing in front of...
Did you place an objection on a record?
I did not.
Did you see your client handcuffed?
Yes, I did.
Did you see your client later that day at Children's Village, Mandy's place?
I did not.
Did you see him on the next day?
I saw him eventually before we were going back to court.
And when you say eventually, what do you mean eventually?
It might have been, my general rule of thumb is when we were in the courtroom and Roy was going to be
Okay, please use
detained.
initials.
When RT was being detained, basically I told him that if he ever wants to contact me, my name is on the file there. He just lets some of the counselors know to call me and I'll come over and see him. I told him basically that he's going to be in a home-like, cottage-like facility, and that basically, all he has to do is have lunch with his father or start some type of dialogue, and that would be, he would be able to go home.
When is it the first time that you saw him?
I'm sure it was probably about a week later at least, because my general rule of thumb is I wait about a week before I go see, someone in there unless they call me.
Sitting in front of you is examiner's proposed exhibit number, I believe, 144.
Yes.
That is the visitor's log for Children's Village, Mandy's place, is it not?
I guess so.
Do you see your name on there?
I do see my name on here.
What's the date?
Forgive me, I don't have my glasses. Does it say 7/9? I believe. Thank you. 7/9.
And that is the first time that you saw your client, correct?
That would be correct.
You appeared on the following day at the Sixth Circuit Court again, did you not?
I believe so, yes.
Between June 24th and July 10th, did you get any calls from the court about how your client was doing?
Your Honor, we're going far afield of the June 24 hearing again. None of this is relevant to whether the judge committed misconduct on June 24.
Phone calls from the court sustained. Go ahead.
You covered for Ms. Cook, did you not?
I did.
Why did you cover for Ms. Cook?
Because Ms.
Your
Cook...
Honor, again, this is
on July 10th.
This is on July
Correct.
10th. This is well beyond what the complaint is.
Overruled. Proceed.
Why did you cover for Ms. Cook?
Ms. Cook asked me to cover for her because she had a pre-scheduled, if I remember correctly, she's involved with the Presbyterian camp up in northern Michigan. They were having a
Director relevant.
50th. She asked me to cover for her. She had scheduled plans.
But you did not see her client prior to the 10th, did you?
I saw her client while I was visiting my client at the, I didn't have any interaction with her, but I saw her on the playground.
Okay. You did not speak to Ms. Cook's client, did you?
Object to relevance, Your Honor. You know, Mr. Dean's not on trial. This is Ms. Cook was not.
Go ahead.
Did you see your client or Ms. Cook's client on the 10th of July?
That's the day that we were in court?
That's the.
Correct.
That's the hearing date?
Yeah.
They were not in the courtroom where I was, but I believe that that is the point in time where it was changed to that they were going to be going to camp, and I honestly do not recall if I saw them that day in the hallway, or I know they weren't in the courtroom, to let them know they were going to camp.
Let me show you. This is your statement, is it not?
This is my statement, that is correct.
Which statement?
The,
Marked as proposed.
It is not marked as proposed exhibit. It is a statement that counsel was provided by this witness. I'm using it only for refreshing of
Your Honor,
memory.
the only reason why I asked
It
is,
would be at a minimum marked for identification purposes.
Your Honor, there are two statements that Mr. Dean has provided. He provided an initial statement, and then he amended that statement, and all I'm trying to figure out is which one we're talking about here.
It has now been marked as examiner's proposed exhibit 156, used only to refresh memory.
Which statement is it, Your Honor? That's my only question.
Would you state the date of that statement?
the date,
If counsel's requesting that you see it, you can show it to counsel under the rules.
I'm certain he has it. That's the statement.
I have both of them. I'm just asking you which one it is. Thank you. It's the amended statement per its title.
Thank you.
Mr. Dean,
yes.
what's the date on that statement?
The date on that statement is May the 12th.
And in that statement, does it not say, I did not see either RT or NT on July 10th?
That is correct.
Okay. So you did not see either child, correct?
I do not recall seeing either child. I know for sure they weren't in the courtroom.
Now, as counsel stated, that is an amended statement that you have provided, correct?
That is correct.
Because the first statement you provided following an interview with me, didn't you?
Yeah, that is correct.
Okay. And in fact,
Your Honor, this statement was only used to refresh his recollection. Now, are we going to be marking it and asking questions about it?
He can ask, she can go ahead and ask questions, unless you're saying impeachment, counsel, or some sort of...
well, right now I have to establish whether he had given any other statements, Judge. And that's what I'm going into.
I think it's been established.
And we'll stipulate that he gave a statement that he then amended, Your Honor.
It's amended. The prerequisite is that there be an initial one.
One would believe.
Between June 24th and July 10th, did you have any conversations with Judge Gorcyca about this matter?
Not that I recall.
Nothing further.
Cross.
Morning, Mr. Dean, how are you today?
You really want to know?
I really do. Yeah, you seem to be holding up well. If there's some other problem I'm not seeing.
No,
You said that you were contacted sometime between 11 and 11:30 by Nicole Rude, correct?
that is correct.
And I think you said that you were informed about the potential for representing a young adult, correct?
That is correct.
Did Ms. Rude tell you what kind of hearing this was going to be?
I believe I was informed of some type of a custody type hearing.
You thought it might be a custody hearing, or did she tell you it was going to be a contempt hearing?
I really don't know. To be an honest answer, I don't know.
When you got to the court, if you followed your normal procedure, you would have checked in with the clerk, correct?
That is correct.
Did the clerk tell you that this was a contempt hearing?
I don't recall.
Was there an order of appointment that you received?
Yes, there would have been.
I just want to show you this order appointing counsel that was, to see if I can refresh your memory. The third box on that order is checked, is that correct?
That is correct.
Does that inform you, or does that remind you whether you were informed of the type of hearing that you were about to participate in?
Yes.
May I have the identification of this item?
I thought it was I said it was the order appointing counsel. I'm happy to show it to you, I'm sorry. Does that refresh your memory as to what type of hearing you were participating in?
Yes, it does, sir.
What type of hearing were you participating in?
A civil contempt hearing.
And you understood that before you actually met with your client, RT?
That would be correct, sir.
Okay. Did you look up the statute then, 600.1701?
No, I did not,
Are
sir.
you familiar with the statute?
Somewhat familiar. I mean, I can't recite it to you verbatim, but I understand there is a civil contempt as there is a contempt in a criminal proceeding. So
Do you know the difference between criminal and civil contempt?
I believe I do in some respects, yes. I
Okay.
believe civil contempt is where there, in my, right now is where the judge or someone in authority is trying to do a coercion to trying to have someone do something.
Okay, so a civil contempt in your mind is trying to encourage future behavior, or future participation with an order, correct?
That would be correct.
Is that your understanding of the type of hearing that we were